Rediscovering the Power of the Express Trust, a modern examination of common law protections in an age of regulation. In today's highly regulated financial and legal landscapes, the flexibility and protections offered by express trusts under common law principles have become increasingly attractive to individuals seeking control over their assets and privacy from statutory oversight. This article explores the historical roots, legal distinctions, and practical applications of express trusts, especially as they compare to contemporary structures like corporations and partnerships. By distilling key concepts from Carlton Weiss's concise trustee handbook and related legal scholarship, we outline how the express trust serves as a versatile vehicle for asset protection, privacy, and autonomy. Section 1, Introduction: The Resurgence of Common Law Principles in Asset Protection. Express trusts, a centuries-old tool of common law, have recently seen renewed interest as a robust alternative to modern corporate structures for individuals who seek privacy, flexibility, and autonomy over their assets. Unlike statutory entities bound by federal and state regulations, the express trust, rooted in common law principles, affords a degree of discretion and independence largely unparalleled by its statutory counterparts. This article revisits the purpose and structure of express trusts, emphasizing the unique ways in which they facilitate the administration and protection of private assets. Section 2, Understanding the Express Trust, a legal distinction rooted in common law. The express trust is fundamentally different from statutory trusts and corporations due to its grounding in contract law rather than legislative oversight. Established through a private declaration, an express trust enables the trustee to hold and manage assets for a beneficiary under terms set exclusively by the settlor. Unlike other entities, express trusts are exempt from many reporting requirements and operate primarily under equitable principles, which prioritize fairness and fiduciary responsibility over rigid compliance. Footnote 1: The General Law Merchant and its relevance. Today, the express trust operates within a commercial framework informed by the general law merchant, an ancient body of commercial law. This system, recognized under Article 1, Section 8 of the United States Constitution, permits individuals to conduct commerce without federal oversight, except in cases of specific income such as corporate dividends. Here, the law merchant serves as a foundational principle, allowing express trust to function independently of statutory commercial regulations. Fletcher, Harvard Law Review, 1984. Section 3, The Role of Trustees in Commerce, a Practical Shield for Asset Privacy and Protection. In today's economy, individuals are frequently confronted with challenges to privacy and autonomy, especially as government and third-party demands for financial transparency increase. The Express Trust offers a unique solution: trusteeship, which allows individuals to act as fiduciaries rather than direct owners of their assets, thereby shielding them from certain liabilities. This position is protected by Article 4, Section 2 of the Constitution, which extends interstate business protection to trustees, allowing them to manage trust assets with minimal interference from state business regulations. Section 4, Sovereignty, Secured Parties, and Trustees in Commerce, Comparative Analysis. While individuals often consider status as a sovereign or secured party to retain control over their assets, these approaches have inherent limitations. Sovereignty as a legal stance requires extensive independence that most individuals cannot feasibly maintain. Similarly, secured party status relies on the assumption of an entity's debtor-creditor relationship with government agencies, which may lack legal support. In contrast, trusteeship in an express trust allows an individual to control assets indirectly, fulfilling fiduciary obligations without assuming ownership. This approach aligns with fundamental principles of contract law and provides a realistic framework for asset management and privacy without statutory entanglements. Berger, ABA Reports, 1978. Section 5, Establishing an Express Trust, Legal Framework and Practical Application. Creating an express trust involves drafting a declaration of trust, a legal document that specifies the trust's purpose, assets, trustees, and beneficiaries. This declaration serves as the constitution of the trust, enabling trustees to manage assets as per the settlor's directives, free from the constraints of statutory incorporation. Courts have consistently upheld the enforceability of such declarations, underscoring the express trust status as a valid private contract protected under common law. Harwood v. Tracy, 118 months, 631. Section 6. Footnotes, documentation, and legal precedents, building a robust trust. This article heavily references key legal precedents and doctrinal texts that illustrate the strength of express trusts under common law. Footnote 1, General Law Merchant, explains the commercial autonomy of express trusts under common law. Footnote 2, Chief Justice Berger's observations on trial lawyers, highlights the importance of knowledgeable administration in express trusts, as only those learned in common law understand the depth of trust structures. Footnote 3, Black's Law Dictionary on Learned in the Law, supports Weiss's emphasis on traditional legal understanding for effective trust administration. Footnote 4, Trust Basics and Fiduciary Equity, clarifies that a trust is enforceable in equity, allowing trustees to act in the best interest of beneficiaries with flexibility unavailable in statutory entities. Conclusion: reclaiming autonomy and privacy in modern commerce. In an era where privacy and control are continually challenged, the Express Trust offers a viable alternative for individuals and families seeking autonomy over their assets. This common law structure, resilient and flexible, aligns with timeless legal principles that emphasize contract-based governance, equitable administration, and personal privacy. Through a renewed understanding of express trusts, we find a powerful and historically supported method for protecting wealth in the 21st century. References: William A. Fletcher, The General Common Law in Section 34 of the Judiciary Act of 1789, The Example of Marine Insurance, Harvard Law Review of Volume 97, No. 1513, year 1984, Reports of the American Bar Association, ABA, 102nd Annual Meeting, pages 205 through 206, year 1978. Henry Campbell Black, Black's Law Dictionary, 1st edition, year 1891. Carlton A. Weiss, Weiss's Concise Trustee Handbook, year 2008.
Your choice in the matter determines wise from fool. Now everything is there for you to rise up higher. The devil is an actor, you must know him as the liar. To those who seek and purified by fire, Jah love could quench to your desire. Now open up and see when the curtain is removed. Satan will be cast into disapprove. Time is the master, it's time to make your move. And Jah will be with you when the tempter comes to you. Yo, devil has to play by the rules. You have to make a choice or be used like a tool. The devil has to play by the rules. Your choice in the matter determines wise from fool. Personalities and principles taking root around, and don't let the actions of a man get you down. Remembrance of Jah purpose will always confound the devil trying to take you to his party downtown. So love your enemy and pray to see the truth, and don't incite rebellion in the hearts of the youth. Now teach them to meditate on the mystic absolute, and teach them to be patient and to be resolute, cause the devil has to play by the rules. You have to make a choice or be used like a tool. The devil has to play by the rules. Your choice in the matter determines wise from fool. The devil has to play by the rules. The devil has to play by the rules. The devil has to play by the rules.